Welcome to Tax Break, a podcast on tax law. I'm Rob Kovacev, a member of Miller and Chevalier's tax group. Today we are talking about tax enforcement under state false claims acts and proposals for allowing tax cases under the federal False Claims Act. False Claims Act has been around at the federal level since the 1860s. It generally provides for civil penalties and qui tam or whistleblower enforcement in cases where there is fraud on the government. It was actually passed initially to address procurement fraud during the Civil War. A lot of states have their own versions of the False Claims Act based on the federal statute. But tax controversy and compliance lawyers haven't had to worry too much about the False Claims Act because the federal statute expressly says that it cannot be applied to alleged violations of the tax code. Then in the 1990s, something interesting started happening. Some states enacted their own versions of the False Claims Act without any limitation on tax claims. And in 2010, New York made a big splash when it expressly amended its statute to allow tax-based enforcement and create a whole component within its Attorney General's office to review and bring those cases. In 2021, the District of Columbia also enacted provisions modeled on the New York statute. And some very high-profile cases have been brought attempting to redress allegations of state tax evasion through False Claims Act litigation. And this raises a lot of questions because there's already a whole mechanism for resolving tax disputes. We have exams and audits, appeals, specific courts and specific provisions for litigation. How does adding a False Claims Act rubric on top of the usual tax dispute format change tax enforcement? Is this going to be a trend? Are we going to see changes in other states or even at the federal level? And what does that all mean to tax professionals and taxpayers? With me to talk about these issues today are two of my colleagues at Miller Chevalier, starting with Joe Rillotta, who's a member in M&C's litigation department, focusing on government investigations and tax controversies. He's a former federal prosecutor and counselor to the IRS commissioner, and he has experience both with tax offenses and False Claims Act cases, including one of the first tax-based False Claims Act cases brought under the New York statute. Ian Herbert is a counsel in our litigation department, focusing on government investigations and related litigation. He has experience advising individuals and entities on a range of issues, including tax fraud, bribery, money laundering, and other financial crimes. So, Joe, I'll ask you first, just for a little bit of background, what is the False Claims Act and why should tax professionals care?
Well, first of all, thank you, Rob, for having us today. And gosh, one reason to care is because this is it is a reality in a couple of significant jurisdictions now that plaintiffs can bring claims having to do with alleged tax evasion under False Claims Acts. But this is something that, at least tax professionals haven't, as you said, have had much occasion to talk about. But it's been around a long time, right? It's kind of an interesting phenomenon. In some ways, there's these parallels between how tax enforcement has developed and how False Claims Act has developed. These processes have developed in almost parallel fashion, yet hermetically sealed from each other. Dating back to the late 1800s, you have states begin to impose income tax. The feds imposed income tax in the early 20th century, and there arose this whole dedicated mechanism for dealing with disputes. There's exams, there's appeals within the IRS and within state revenue authorities, and there is, in many jurisdictions, just a dedicated court system that is at least available to essentially have a kind of a particularized fast-track litigation to deal with tax controversies. And there's a lot of emphasis on the peculiarities of the tax code and on harnessing expertise on the part of enforcers and on the part of adjudicators to get to the right issue and to impose penalties where appropriate. We have these very dedicated lanes. There's civil enforcement. There's criminal enforcement. In between, there's these various types of civil penalties. And we all know that lay of the land if we're tax practitioners. And there is a role for whistleblowers in the tax process, but it's a relatively informal role. Whistleblowers can go into the IRS or to state counterparts, and they can, attempt to kickstart an enforcement action, and maybe they can even get a financial award. But there's nothing that's really highly articulated as far as what their rights are, or what their expectations are. It's sort of in the discretion of the enforcement authorities. So that's the tax side. Like I said, in parallel, you have False Claims Act developing for almost that same period of time. And this is, in contrast to the tax proceedings, it is a mechanism of general enforcement. It applies to just about any instance of a fraud on the government. And it has sort of applied historically, as you mentioned, in procurement fraud, but also really in any area where there is a government program. And you see False Claims Act, for instance, applied in healthcare cases. So, as you note, under the False Claims Act, by very design, whistleblowers play a very prominent role. The government can bring suit under the Act directly, but there is a specific procedure for whistleblowers to file a complaint and to trigger enforcement activity by the government agency, to trigger a proceeding in front of a court of general applicability. Now, these are civil proceedings. There's a civil burden of proof and all of that, and a lot of the civil rules of evidence and procedure apply. But the person that sues on behalf of the government can recover multiples of the award of the amount that ought to have been paid to the government, and so there is essentially it is a penalty statute. And I say these two sort of worlds have been sealed off from each other because there is an express provision in the Federal False Claims Act that states very clearly this act may not be applied to allegations arising under the Internal Revenue Code. And many of the states that have adopted False Claims Acts based on the federal model, whether by inertia or by intentional design, they have copied the feds and included this exclusion, this bar on tax enforcement. And there's a sort of a rationale for it, which I alluded to earlier. We kind of have this notion that tax ought to be enforced by specialists, that it's a complex and unique area. And as I mentioned, there's that whole sort of history of tax enforcement. There's also this notion, right, that taxes touch everybody. It's not just a matter of having a regulated party or a company that chooses to play in a space that involves the government. Everybody has to pay taxes. There's no avoiding it. That means everybody has a tax obligation. And there's a thought that if you allow this very sort of whistleblower-oriented False Claims Act enforcement mechanism to be applied to taxes, you would have all sorts of discord, right? You would have business partners who, perhaps become disenchanted with each other, hurling allegations that their counterparts weren't compliant with taxes. You might have ex-spouses who were levying allegations against each other, that sort of thing. And that's part of what historically has predicated this tax bar. But then, as you mentioned, things changed. I think Ian and I did a little bit of research just in connection with an article that we wrote on the subject a couple months ago. And there was also a very insightful presentation at the ABA tax section. I tip my hat to Ben Eisenstadt at Kaplan and Drysdale for that. But we took a look at the history. And we saw that there was actually a False Claims Act that was enacted in Florida that did not have a tax bar. Now, Florida, if I'm not mistaken, doesn't have an income tax for individuals. So maybe it didn't have that sort of a high profile effect, or maybe it was less sort of politically radioactive on account of that. But for whatever reason, Florida had this relatively different statute. And there were a couple of other early adapting states that modeled their version of the False Claims Act on Florida that did not. Many of these states didn't have income tax, but now they had a False Claims Act that at least theoretically allowed tax enforcement claims to be brought under it. So you have other kinds of tax. You have sales tax. You have corporate income tax, and these kinds of actions, these kinds of enforcement actions, are brought under those state False Claims Acts. And then, this progresses, mainly in the early years applied against corporations in states that either had no tax bar or that had a modified tax bar. Then all of a sudden, New York goes and amends its statute, not only to allow False Claims Act, not only to be sort of, to remove a tax bar, but to expressly allow False Claims Act enforcement against individuals with respect to income tax. And there are certain limitations in New York which are kind of interesting, I'm sure we'll get into that later. But the gist of New York's model was that this statute would be applied exclusively against high earners. So this would be people who made more than $1 million a year in income. Maybe that made this sort of innovation a little more politically palatable, and it got the conversation started, right? Because within a couple of years of having the statute enacted, we started seeing high-profile cases hitting dockets and newspaper headlines and so forth. And so some other states have taken note, and there's been legislation across the country to potentially model additional state False Claims Acts and local False Claims Acts on New York's. And this, as you mentioned, this actually ended up happening in D.C. in 2021 when D.C. City Council essentially copied New York's law, and that went into effect last year, and it's already generated some cases. So, is this a trend? It certainly is a trend. We'll see if it continues to spread. And as you mentioned, there's an inkling of a suggestion that maybe the feds ought to be watching and may want to copy some of the states out there.
So, as I understand it, False Claims Act. Oh,
guys,
go ahead.
Should we take a quick pause? Molly said her Wi-Fi dropped out.
Oh, I didn't do it.
I wanted to. It just popped up a minute ago, but I wanted Joe to finish his answer.
Yeah, when I was distracted, that was why. I just took a look over and I saw a bubble from Molly. But yeah, I guess we'll just wait.
Okay.
We're just destined not to do this podcast.
Yeah, it's cursed.
I think I actually liked my first run this morning better, but whatever. We'll just roll with it.
What can you do?
Yeah. Oh. I mean, can we go on without her? I mean,
I'm not sure.
You know what? Why don't we try, and then that way we can use the time. And if she comes on and says it doesn't, I mean, we're just sitting here, right? So
that's true.
Let's just do it.
Yeah. Well, let's see. She said at 12:11. She said, "Give me a minute or two." So, all right.
Let's just keep going and see what she says when she gets back on.
Yeah.
Okay. Great.
All right. Okay. So as I understand it, it's the Attorney General's offices that basically ride herd over tax False Claims Act cases.
At the state level, yeah.
At the state level. But usually it's the tax authority, the Office of Tax and Revenue, or whatever the version of the IRS the state has, that does all the tax enforcement. Do the two agencies talk to each other? What kind of coordination goes on between them?
Yeah. So, I guess there's probably as many answers to that question as there are states that allow tax enforcement under FCAs, right? But yeah, it is the Attorney General's office at the state level that typically it brings these cases and that assesses whistleblower allegations and that decides whether the government is going to intervene in these matters. And we'll get a little more granular about what this process is, I think, in a minute. But yeah, the AG's office is generally in charge of the False Claims Act. It owns the False Claims Act. And the AG is, of course, independent from the Revenue Authority. It's often the case that AGs are elected. And if they're not elected, they're generally high-profile political appointees who may have eyes on higher office. So they're going to have their own sorts of incentives. And they may want to do things a little bit differently. than the revenue authorities. And there is a little bit of tension, almost inevitably in those kinds of situations. But on the other hand, they do recognize that they have to work together. And at least, in my experience, there is cooperation. Generally, when cases are brought, both the revenue authority of the state and the attorney general's office provide insight and collaborate. And when there is a resolution, if it's a settlement, it seems to be more often than not the case that there's a closing agreement that makes peace with all of these agencies.
Okay. So, who are these relators, these whistleblowers? What what kind of person is it, and where do they get their information?
Okay. Yeah, that's a loaded question. Go ahead, Ian.
Yeah, it's hard to know. It's a loaded question. And let me just take a step back and just talk briefly about the False Claims Act and the federal False Claims Act, the state ones are modeled on, and just explain a little bit about how you get here and what these whistleblowers, who these whistleblowers are that are filing the cases and how it works. The So the FCA creates liability and treble damages for anybody who knowingly presents or causes to be presented a false or fraudulent claim for payment. And it is an interesting hybrid structure. So it's all civil litigation rules. You have to dust off your federal rules of civil procedure, and but these are inherently sort of quasi-criminal claims for fraud. And the whistleblower, Rob, that you referred to, usually is the one who starts a case, and they actually file a complaint in court, and it's on behalf of the government. The whistleblower is referred to as a relator, and the complaints are quitam suits. And quitam is part of a Latin phrase that says that you're suing on behalf of the king. And so the case is actually in the name of the government, but the government hasn't actually brought the case yet. It's the whistleblower who brings it. And the complaint is filed under seal, and the suit is frozen until frozen before the defendant even gets is served with the complaint, while the government investigates and decides whether it wants to step in and bring the case. And so that the first time that a defendant might get sort of any inkling that there's a suit is probably when the government issues a civil investigative demand for documents related to the matter. The government can issue these demands to third parties or to the defendant while it's investigating the case and trying to decide whether to step in. And that's the first big decision, is whether the government is going to step in and take over the case, and that can sort of bring the case in a couple of different directions. And so the relator, going back to your original question, Rob, the relator is someone who has sufficient information to bring a complaint on behalf of the government. There is a requirement that the information not be public information, right? And so, as a practical matter, the relator is somebody who has inside knowledge of the company. In many cases, that's a former employee. A business partner could also be a relator, but they can sort of come in all shapes and sizes.
And their motivations vary, right? I mean, or at least they can. You've got a financial award, so that's at least going to factor into the whistleblower's incentive. Most whistleblowers are going to be interested in getting that award, but some might be motivated by genuine discontentment with what their employer or the target, whoever that may be, with what they're doing, and a genuine belief that there isn't tax compliance. And so you kind of have, as in any large universe of people, you're going to have some who are more sort of public interest oriented and some who are kind of maybe more cynical. It really there's no shortage of variations on that theme. But yeah, look, but for employees, current and former employees, do feature prominently in the universe of people who bring qui tam suits. In part because, as Ian mentioned, there is a requirement in the federal statute and a lot of the state statutes that the claim be predicated on non-public information, and this is to prevent people from just reading the paper and deciding they don't like something and filing a lawsuit based on it. But regardless of who your whistleblower is, what their motivations are, it's inherently this kind of three-dimensional chess, right? Because you've got to deal not only with the government, but with this private party, and their interests may be different, and their insight and their worldviews may be a little bit different. But unlike in a tax case, they each have a seat at the table, and they each have an ability to influence how the adjudicator, how the court, resolves the matter.
Now, what kind of, I guess it's called False Claims Act. Is it just any mistake on a tax return that would trigger a False Claims Act case, or does it have to be fraud or some heightened level of intent? How does that work?
So the standard, obviously, the test will change by statute, and so when we're going, state by state, sort of what qualifies as a false claim will change a little bit. But the general idea is someone who knowingly presents a false claim to the government, knowingly provides a false statement to the government in order to receive money. And knowing is defined in the federal statute as knowing, reckless disregard, or indifference to the truth. And so it's not sort of, it's a broader definition of knowing, but it's not any mistake on a tax return, right? There does have to be scienter, a knowing component to it that sort of creates more of a fraud.
Although what's interesting is that it's not exactly the same standard that applies, say, to a fraud penalty under the Internal Revenue Code, where you've got to have really, a heightened kind of knowledge. Recklessness can, under the jurisprudence of a lot of states and under the federal jurisprudence, suffice. So it's in some respects it's a little bit of a broader net than what you might catch under a straight conventional tax penalty provision.
So if you're a taxpayer and you live in or do business in New York, D.C., one of these jurisdictions, how do you prepare for this? How is it different from preparing for an audit by a tax authority?
Well, that's interesting, right? Because preparation, I suppose, depending on how you conceptualize that, it can go back before there's an investigation, before there's a case, a controversy of any sort. You can really sort of think about this as how do you prevent a False Claims Act or case from arising, or how do you minimize your risk under a False Claims Act, and that maybe presents a little bit of a different analysis than tax departments are used to undertaking. Maybe this is where you've got to sort of look to see what general counsel's offices are doing, particularly for regulated industries in places like healthcare and in government contracts. You really obviously taxpayers do care about compliance, and there are plenty of firms out there that do what they're supposed to do as far as vetting tax positions and conducting all of that analysis. When there's a potential for a qui tam suit, you do all of that same stuff, but you might be more careful about documenting things. It's almost like you're constantly always in pre-litigation mode, because there's always the potential, then a relatively low threshold for somebody to initiate litigation. And I know that this is probably just horrifying folks out there who've never had to think about the False Claims Act, but it's like anything else. You do sort of, you appreciate the risk. You can never eliminate it completely, but you can sort of, undertake best practices to minimize it. And a lot of companies do this sort of thing in non-tax contexts already, and it may just be a matter of tweaking, what compliance mechanisms are out there, making sure that you have the whistleblower hotline, making sure that concerns that taxpayers have, are addressed. That employees or other affiliates have are addressed. That's not going to deter all relators, right? Because as I mentioned, you're probably going to have some people who are cynical and who are going to, or who are just not capable of being managed and are going to do the unfortunate thing regardless. But it is going to deter some people, and it's going to, I think, help to manage that risk. And then once you're in investigation or litigation, if you find yourself there, you take it one step at a time, and you remember that the government is potentially not yet sold on the case. There's a relator that's bringing allegations, and the government may be still in the process of getting up to speed. And one of the sort of key features of early stage False Claims Act advocacy, if you represent a target or a defendant, is trying to sort of, to the extent your facts permit and to the extent your circumstances permit, trying to draw a wedge between the relator and the government. Because if the government decides to intervene, that's a whole different case than if the relator is bringing the suit on its own. So you want to keep the government ambivalent. You want to keep the government on the sidelines. You want to keep the government a little bit skeptical. And if you hit the home run there as an advocate, you can actually potentially, at least in theory, persuade the government to intervene for the purpose of dismissing a case. The government can do that, and if you convince them that there's absolutely no there, and this is just the relator going off on the wrong track, that's a possibility.
Okay. I understand there was a recent case in D.C. involving the Tax False Claims Act provisions in the district. Do you have any thoughts about that case?
A few. You want to weigh in, Ian?
Sure. Yeah. So I'll set it up. So the DC case is one brought against an individual, Michael Saylor, who and his company, MicroStrategy, which is a publicly traded software company. It's incorporated in Delaware, and it has a principal place of business in Tysons Corner, Virginia, just outside of the district. And Mr. Saylor founded the business in the 1980s, and the complaint alleged that he has lived in D.C. For the entire life of the company. There's lots of allegations in the complaints about the houses that he purchased in D.C. and the social media posts that he made that suggest he lived in D.C. But he never filed income tax in D.C. He filed mostly in Florida, where he has a house and a driver's license and is registered to vote. And the D.C. Attorney General and the relator alleged that the Florida conduct was all a pretense and that he was not filing taxes in D.C. when he should have been, and claiming residency in Florida for the purposes of state income tax. And as Joe mentioned earlier, D.C. began to allow for claims for tax-related false claims in the beginning of 2022. The statute was passed in 2021 and then started to bring claims in 2022. And there was a claim brought in August of last year against Saylor and MicroStrategy. And both of them, the claim was actually quickly unsealed within about a week, which isn't always the case. But then there was a motion to dismiss brought by the defendants. And the key here is that the defendants were arguing that there was no actual false claim to the government because Mr. Saylor and MicroStrategy never filed a tax return in the district. So they never actually made any statement to the district that was false. And the Attorney General's argument is the failure to file a tax return is enough of a false statement to trigger FCA liability. And so we got a ruling just a month ago from DC Superior Court. And
when he says we don't represent anybody in that case, of course. That's just like
we as watchers of the court,
People, yeah.
people interested in the case, got a decision from the court a month ago, which agrees with the defendants that there is no FCA liability for a failure to make a statement to DC in this instance. So it's a really interesting case, and I think we could talk about the sort of the ramifications of it. But I don't know if Joe, you had anything to add to sort of that high level description.
Sure, and of course it's on appeal, I think, or it soon will be. I'm sure it soon will be if it isn't already. Yeah, I mean, a couple of additional thoughts. I mean, first of all, as Ian mentioned, this is one of the first DC False Claims Act tax enforcement cases, and it was the big one, right? I mean, this is the one that the Attorney General's office obviously invested a lot of time in. It's a really splashy complaint that includes pictures of the alleged residence of Mr. Saylor in Georgetown. There were a few minor, maybe one or two minor DC False Claims Act cases before this, but this was the one that was going to sort of announce to the world, hey, this is here. And it obviously didn't go the way that the Attorney General's office contemplated or expected that it would. But this is a perfect illustration, Rob, of how you've got to look at the actual statute and pay attention to the sort of local eccentricities and particularities, right? Because the DC statute was modeled on the New York statute. And the New York statute, of course, if you go way back, it was modeled on the federal statute. The federal statute allows generally False Claims Act claims to be brought where there is a fraudulent claim that is made to the government, right? So if you're applying for a grant or for any kind of funds or for a tax refund or not tax in the federal system, but for a payment from the government, that's an affirmative false claim. There's also what's referred to as a reverse false claim provision in the federal statute. And that is where if you owe something to the government, like, say a customs duty or something of that nature, and you fraudulently conceal that can be the basis for a False Claims Act claim. Okay. So there is this concept in the federal statute that, hey, you don't necessarily have to affirmatively submit a false claim. But when New York created this particular provision for tax, they, whether intentionally or not, and I've heard actually competing accounts, the legislature put in language that was very much limited to affirmative claims, right? So, affirmative false statements that were made to the government. So, tax returns, right, that are filed. And DC, again, whether with intentionality or not, they copy this exact language. And if you look at the language in terms of the most natural reading of the text, it seems to apply to actual affirmative false statements. And that's certainly what Mr. Saylor's lawyers argued, and they prevailed at the trial level. The trial court said that this does not apply to a situation where the taxpayer doesn't file a return. Now, from the perspective of the DC AG and revenue authorities, this may be particularly unfortunate because some of the biggest cases that Office of Tax and Revenue in DC has been concerned about over the years are residency fraud cases, where almost by definition there is no local tax filing. The taxpayers live in DC but pretend to live elsewhere. And at least if this precedent holds, those are not going to be cases that can be prosecuted under DC's False Claims Act. Now, interestingly, New York has of course become more sensitive to this notion that non-filers, perhaps cannot be prosecuted. And after Saylor, it's probably more. There's probably a likelihood that a similar decision would be reached in the case of a non-filer case in New York. There's actually been legislation to re-amend the New York False Claims Act to specifically allow cases against non-filers. And, at least last time I checked, that hasn't gone anywhere. I think if I'm correct, the governor actually vetoed that, right?
Last year,
Yeah.
It was vetoed by the governor, and I think I checked again this week just to make sure, and there's no new legislation pending as of a few days ago.
Right. So, we'll see what the DC City Council does if they try to re-amend the DC False Claims Act to allow claims against non-filers. But, if they don't, and if this decision holds on appeal, then, that's going to be, the DC Act will be much more limited than perhaps the Attorney General's office contemplated initially.
So, do you think that there's a chance that there might be a federal False Claims Act tax provision? And what do you think the consequences would be if that did happen?
Gosh. So, we've talked about this, and I know that there are certain factions on the Hill that are very sort of pro whistleblower, right? And it's a weird ideological mix, right? You've got, Senator Grassley, who's been a big fan of whistleblowers for years, and Senator Warren, right? And so you've got, this sort of like odd bedfellows contingent of people who are always sort of trying to promote whistleblower roles in tax enforcement. And, this is just sort of my reflection on the False Claims Act. I look at this one sort of sentence in the act that excludes income tax or tax-based claims, and I think, gosh, it would be really, technically, mechanically kind of easy to get rid of this, right? All you need is for one sentence to be slipped into one of these like omnibus like packages of statute that seem to get enacted every year, the National Defense Authorization Act or whatever. One throwaway line that repeals 31 USC section 3729D, and then all of a sudden there's no tax bar. And that would just sort of, I think it'd be an understatement that to say that would just create, maybe chaos is too strong of a word, but maybe not. It would certainly put us in uncharted water in terms of how to, manage and navigate federal False Claims Act tax enforcement. Because as it currently stands, we don't have a separately elected Attorney General, of course, at the federal level, but we do have different components of the Department of Justice that handle tax stuff and False Claims Act stuff, respectively. And of course, you've got the IRS, which is not just going to sit back and let whistleblowers, direct tax enforcement. So, yeah, that would be just a tremendous and potentially chaotic development, at least in the sense of creating a stir. And it would have to be just navigated by whatever administration is in place when such a thing happens.
But one additional point to that, and the reason why I think it might be more complicated. I agree that just repealing the tax bar would be the most straightforward and sort of direct way to add tax claims to the federal False Claims Act. I think there would be little appetite for a full repeal of the tax bar. Most of the states that we've seen, as Joe sort of alluded to at the beginning, that have repealed the tax bar entirely, they often don't have income tax. Others have limited it, like New York and DC, to just high income filers. And I think there's sort of a real practical reason for all of that. One is sort of where you want to put your resources. This is a case where, when the relator files the claim, it goes to the government and they have to review the case and decide whether to step in and bring it forward. And so, there's a resource question where the government doesn't want to be, running cases that don't have sort of high value damages at the end of them. And then sort of going back to another point Joe made, where sort of, nobody escapes the obligation to pay taxes. You sort of open it up to, every restaurant where a server sees another server not input cash tips, and just like you can just see like complete chaos if you sort of don't have some threshold levels, or some sort of tax bar on FCA claims.
And by the way, I don't know exactly how this cuts, but just a sort of bit of trivia. Before there was an express tax bar in the Federal False Claims Act, there was actually case law that deemed the False Claims Act not to apply to Title 26 cases, just based on sort of reconciling the False Claims Act and the Internal Revenue Code. Now, obviously, legislation, if legislation is actually affected to affirmatively repeal the tax bar, then that would call into question that jurisprudence that effectuates a tax bar on the principle of reconciling different statutory schemes. But I certainly agree. It would be a significant transformative event in federal tax enforcement, and if it did happen, you would see a lot of stakeholders within and outside of the government just sort of scrambling to try to articulate what this all means, and figure out a way to manage all of those resource allocation and procedural issues that Ian was alluding to.
All right. I'll just ask each of you if you have any final thoughts or you'd like to sum up what your view of the state of play in the state False Claims Act tax area.
One thing, going back to the DC law, there's sort of an interesting part of the trial court's opinion where the judge says that, and doesn't make a ruling on this, it's all dicta, but the judge says that maybe any false statement could apply, any material false statement could apply, and so you could have the court alludes to the fact that maybe you could have sort of company books and records, or any sort of statement to the government confirming company books and records, or even the court says false tax filings from other states. And so maybe before the DC Council amends, I would expect sort of the next thing you'll see in DC might be a case where the Attorney General says that the false statements include some of these sort of peripheral false statements that maybe aren't statements made directly to the DC government, but could sort of fall under the statute. And then, from there, I think there's a real question, sort of how many more states are going to do this. There's discussion in California and Michigan, a handful of other states where legislatures are thinking about repealing the tax bar in one way or the other, and sort of seeing, how the DC courts have handled it, how New York has handled it, I think will inform some of those decisions. And, you might get more states that are repealing the tax bar and then being very more specific about what is and is not allowed.
I think that's a really good point. This is there's a couple of things that come to mind, and one of them is just sort of like, I can't get it out of my head, so now I'll put it in your heads too. I just, I don't know if you guys are fans of Seinfeld, but there was this sort of episode where, George Costanza was just kind of complaining about worlds colliding. This is going to be the end of Independent George, right? Like sorry about that. There's these two different disparate universes of enforcement, and they're potentially being melded together, and now you've got this sort of this uncertainty that results, and it's almost inherent in the nature of this kind of development. But this is kind of what we do in this country, right? We've got 51 different jurisdictions. There's laboratories of democracy. and we see whether something plays out, whether it's a good idea or a bad idea, and if an idea gets traction and one state finds a way to make it work, other states might copy, and maybe the feds would copy. So I think we just have to kind of wait and see. There is an element of like chaos theory to this, right? Because you've got like New York implementing all of these very specific provisions to address some of the concerns that everybody has about tax enforcement and whistleblowers and all of that. So they've got all of these different rules, all these boxes you got to check, and whether by design or just inadvertently, as the Saylor case illustrates, they might have, by virtue of implementing all of these rules, carved out a whole area of tax enforcement that they might have wanted to pursue under the False Claims Act, right? So if Saylor holds, if it applies in New York, then New York can't pursue residency fraud cases either, potentially. You fix one issue from the policymaker's perspective, you create another. So it's just going to have to hash out. I think we're just going to have to see if states can make it work in a way that is palatable, in a way that accomplishes what policymakers want to accomplish, and we'll take it from there.
All right. Well, Joe and Ian, thank you so much for sharing your expertise with us, and thank you for listening. This is Tax Break.
Produced by Heartcast Media.